All right, thank you. We will go on the record
Thank you.
in the matter 22 CF 93, State of Wisconsin versus Tristan Aniny. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Aniny appearing by telephone conference with approval of the court. We have his counsel, Michelle Erdman, appearing by video conference. We're set today for a plea and sentencing hearing. Before we begin, Mr. Aniny, you are appearing by telephone and your attorney is appearing by Zoom, by a video.
Notice how the judge immediately confirms the defendant has already given DNA and fingerprints? That's standard procedure. Courts lock down identity before moving forward. No wiggle room here.
And you have requested to appear this way, is that correct?
Yes, ma'am.
And do you understand that you have the right to be here in person if you wish?
Yes, ma'am. Logistically, it's not feasible.
And I understand that. I just have to ask this. I have to put it on the record for appeals purposes, that kind of thing, okay?
Tristan is appearing by phone while his lawyer's on Zoom. Interesting setup, right? Judges have to make sure defendants know they could have been there in person. Otherwise, appeals could argue they didn't get a fair chance.
So do you understand that if you have any questions or you have any concerns, I will send you both into a confidential breakout room so you can discuss anything that you wish with your attorney, okay?
Okay.
All right. Ms. Erdman, the parties have reached an agreement. Can you please recite the agreement for the record?
Judge, we filed a plea questionnaire some time ago. It was document number 46. Mr. Aniny is going to be pleading to 3 misdemeanor level charges today. Misdemeanor possession of amphetamine, possession of a controlled substance, and then possession of THC. And Your Honor, the parties have agreed that he would be on 2 years of probation, and the standard terms of conditions of probation, including AODA and follow through and complete any programming that he's enrolled. I think that's kind of expired since the prior agreement was entered, but we would expect if he is ordered to do any, or if his probation agent feels anything would be useful, that he would follow through with that treatment as well, Your Honor.
All right, thank you. And Mr. Aniny, you live in Richfield, Minnesota, is that correct?
Yes, ma'am.
And that's on West 72nd Avenue?
Yes, I believe. It's either Avenue or Street.
Okay, thank you. All right, and so he'd be pleading to 3 misdemeanors and we're asking him to stay on Burnett County probation?
Yes.
Okay. And so, Mr. Aniny, do you understand, and before I get into taking your plea, I just want to make sure that you understand that if the court does follow the recommendation and does place you on a period of probation, that it would need to be through Burnett County office. It cannot be transferred, most likely, because of the interstate. Now, the interstate compact, they have agreed, or they do not wish to accept misdemeanor pleas for their probationary review and oversight. So do you understand that you would sometimes maybe need to come in person to Burnett County to your probation agent?
I did not understand that. I'm hearing it now, and that sounds kind of difficult. It took me 2 years to get up this last time.
Here's where it gets tricky. Probation in Wisconsin can't always transfer across state lines for misdemeanors, meaning Tristan might actually have to travel back from Minnesota just for drug tests. That's a big deal most defendants don't realize until it's too late.
Okay, so I can't guarantee that they won't transfer it. I can't guarantee that they will transfer it, but there is a possibility that you may at sometimes need to come in person for some random drug screening. You may not. I'm not the Department of Corrections. They may have you just do Zoom appearances. I'm not sure. I just want to make sure that you understand the ramifications of having a probationary recommendation.
I'm beginning to. Thank you.
All right. So at this time, would you like to have a little breakout session with your attorney, or do you feel comfortable enough to proceed with the plea and sentencing?
I don't want to waste anybody's time here. Let's roll.
Let's roll. Okay. All right. So I do have in front of me a plea questionnaire waiver of rights form. And you did sign it some time ago on October 3rd, and it's 2023 because you were ready to plea.
And here's the drama. Tristan was ready to plead back in 2023, but he didn't show up. The court issued a warrant. He claims he turned himself in later with his dad's help. What do you think? Responsible choice or just damage control?
You were ready to be sentenced, but then for some reason you didn't appear and the court issued a warrant, and it was some time before you were either, I believe you were picked up on the warrant. Is that correct?
No, it's not. Well, it may have been at one point, but he turned himself in. He wanted to get this matter addressed, so he came there. His dad gave him a ride back last month.
All right, so that's good to know. All right, so
Earlier
Mr.
this month.
Anthony, this was signed on October 3rd, 2023. And Ms. Erdman, you're indicating that he understands everything. You went over everything on this plea questionnaire and everything is still accurate and true other than those other conditions such as the AODA and fall through because he's been through treatment, correct?
That, and I suspect he's probably gotten a little older, but other than that, I think everything should be accurate, Judge.
Yes, I'm going to guess he has since it is now 2025. Okay, Mr. Ankeny, how old are you?
91. I'm 34, I believe.
You're 34. All right, so you're 34. And do you remember accurately what is in this plea questionnaire, and do you understand it?
Yes, it's basically dropping 2 felony counts down to misdemeanors and agreeing to go on probation.
Right, and it had a whole lot of other things on this.
Did you catch that? Tristan says, I don't think I'm that smart, but I get the gist. Judges hate vague answers like that. They need crystal clear understanding, or the plea could be invalid down the road.
Such as your constitutional rights and what you'd be giving up, and some other things. So your attorney went over this with you, is that correct?
Yes, ma'am.
And so you understand everything on this document?
Well, I don't think I'm that smart, but I get the gist.
Well, I need to make sure you are that smart, that you understand everything. And I'm going to go over quite a bit that's on this plea questionnaire. But when your attorney went over this with you, did you at that time understand what she was explaining to you?
Yes, ma'am.
Okay. And so I'm going to refresh your recollection. I'm going to refresh your memory and go over some of these things with you again, but not in exact detail, okay?
Okay, thank you very much.
So you're pleading guilty to 3 misdemeanor counts. First, I have to ask the state formal motion to amend count 1 to possession of amphetamine.
So made.
Granted. So you're pleading guilty to possession of amphetamine, possession of a controlled substance, and possession of THC. Is that all correct?
Yes, ma'am.
You're 32 years old. You're 34 years old. You have 16 years of schooling. You can read, write, understand the English language. You have not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
No, ma'am.
And you are currently receiving treatment for a mental illness or disorder. And would that be your substance abuse disorder?
Yes, and depression.
And depression. And so with your depression, are you in a place right now where you can fully understand and comprehend what's going on?
I am cognizant, coherent, and capable.
I'm very glad to hear that. Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that document. I will briefly go over those rights with you to make sure that you understand what you're giving up. You will no longer have the right to a trial. You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or to remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
Oof. Crazy times we live in, but yes.
Yes, but legally, and I'm told I must ask that question to everybody just in case, so you understand that you could be deported. And so it gives you an opportunity to think a little bit more carefully about your decision. So do you also understand that here, the state would have to prove as to the amended count 1, possession of amphetamine, that you possessed a substance, the substance was a controlled substance in an amphetamine classification, and that you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would need to prove?
Yes.
And do you understand the maximum possible penalty could be a fine of up to $5,000 or 1 year of incarceration or both?
I understand.
You understand as to count 3, possession of a controlled substance, the state would have to prove that you knowingly possessed diazepam, a controlled substance without a valid prescription. Do you understand what the state would have to prove?
Yes, ma'am.
You understand the maximum possible penalty could be a fine of up to $500 or imprisonment of up to 30 days or both. Do you understand that?
Yes, ma'am.
As to possession of THC, do you understand the state would have to prove on or around April 10th, 2022, that you knowingly possessed a controlled substance, THC? Do you understand? And do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 6 months or both? You understand that?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea here today?
I do.
Do you have any questions for the court or for your attorney before I proceed?
I do not believe so.
You understand that there is a recommendation for the court to place you on probation with certain conditions. Do you understand I'm not bound by that recommendation?
Judge, Mr. Aniny has been someone who's gotten a hold of me repeatedly over the years, just trying to get this figured out and resolved. He's the one that proactively reached out to me and said, hey, I think I can finally figure out a ride. I've got my dad lined up. He came in, gave his DNA, got everything set up that way, made the appearance. He's been pretty diligent about trying to get this resolved, even though the challenges with transportation have been long. I do think that when I speak with him today, I hear a clear-headed young man that seems to be doing the right things. He's committed to, I think, staying out of trouble, addressing his issues, and he's definitely on the right path. So for those reasons, Your Honor, we just ask you to consider the recommendation.
All right, get the bond done, and then you can come sign it, okay? Who is in the county jail? Is this Mr. Tulgren? All right, Mr. Tulgren, can you hear me?
Yes, I can.
Thank you. We will go on the record in the matter 23 CM 161, State of Wisconsin versus Ryan Tulgren. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Joel Feliski in person. We have Mr. Tulgren by video conferencing in custody in Burnett County Jail. We're set today in this matter for a plea and sentencing. The court had issued a warrant for a failure to appear. Mr. Tulgren was picked up on that warrant. However, the parties have reached an agreement. Mr. Feliski, do you have documents for me?
I do, Your Honor. I'll recite on the record here that Mr. Tulgren has agreed to plead to counts 1 and 3 in the complaint for 23 CM 161. The remaining counts are going to be dismissed and read in. The parties are making a joint recommendation for on both count 1 and count 3 of $500.
And here comes the kicker. Tristan thought Wisconsin had legalized marijuana. Nope. The judge shuts that down fast. Big reminder, state lines matter. What's legal in Minnesota can still get you charged in Wisconsin.
Fine, inclusive of costs, to total $1,000. I have a completed plea questionnaire with me. May I approach?
May. Thank you. Do you want your clip back? Mr. Tolgren, I have in front of me a plea questionnaire waiver of rights form, as well as a document that has the elements for these offenses. And it appears that your signature is on both of these documents, or your initials. Is that correct?
Correct.
You actually sign RT. Is that correct?
Correct.
And you heard the agreement that was reached and that was stated on the record?
Yes, I did.
You are pleading guilty to 2 misdemeanors. You're 45 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Correct.
Did your attorney thoroughly go over these documents with you?
Yes, he did.
Did he essentially read them to you word for word?
Yes, he did.
And you understood everything completely?
I did.
You understand that because you allegedly committed crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes, he did.
Do you understand them completely?
Understand him completely.
And do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, I do.
Do I need to go over these rights with you in any more detail?
No, you do not.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand the state would have to prove as to count 1, misdemeanor bail jumping as a repeater?
Yes, Your Honor.
Yes.
As a repeater, that in Burnett County, Wisconsin, having been charged with a misdemeanor in Polk County case number 23 CM75, and having been released from custody, you intentionally failed to comply with the terms of your bond by operating a vehicle without an ignition interlock device. Do you understand what the state would need to prove?
Yes, I do.
Do you understand that upon conviction, you could face a fine of up to $10,000 or imprisonment of up to 9 months or both? But because there's a repeater, that means the maximum term of imprisonment for this underlying crime, because it is a misdemeanor in Polk County case 20 CF39, and it has not been reversed, that the maximum term of imprisonment may be increased to not more than 2 years. Do you understand that maximum penalty?
Yes, I do.
And you understand that as to count 3, operating a motor vehicle while revoked as a repeater, do you understand the state would have to prove that on the same date and time in Burnett County, Wisconsin, you were a person whose operating privileges have been revoked. However, you operated a motor vehicle on a highway during this revocation period. Do you understand what the state would have to prove?
Yes, I do understand.
Do you understand the maximum possible penalty for the underlying misdemeanor could be a fine of up to $2,500 or imprisonment for not more than 1 year in the county jail? But because you were convicted in that Polk County case and that was unreversed, and you're pleading as a pleader or as a repeater, the maximum possible penalty could be increased to not more than 2 years. Do you understand what that means?
Yes, I do understand.
You understand that there's a recommendation to the court for costs only for both of those counts, but do you understand I don't have to follow that?
Correct.
Said differently, I could sentence you to the maximum possible penalties if I thought it was warranted. Do you understand that?
I do understand.
Do you still wish to proceed and enter a guilty plea?
I do.
You are pleading guilty by video conferencing. Do you understand you have the right to be here in person?
Correct.
And you're waiving that right?
I'm waiving that right.
All right, thank you. If you have questions or concerns and you need to speak with your attorney, let me know. I'll send them to our Zoom room and give you a confidential session, okay?
Okay.
Did your attorney go over the facts of this case with you that are alleged in that criminal complaint?
He did.
And do you understand those facts as they're alleged completely?
Yes, I do, completely.
And I'm not going to have you say that each of those allegations is 100% accurate and true, but for the most part, as to the crimes you were pleading guilty to, are those facts accurate?
They are accurate.
Mr. Feliski, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you Mr. Tolgren, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing,
Yes.
and voluntarily?